Are you thinking about transferring assets to countries that do not adhere to the CRS in order to avoid the automatic exchange of tax information? Be careful, this strategy can expose you to extremely serious risks with criminal consequences. At ICAA International Law Firm, we assist entrepreneurs and private individuals involved in investigations for concealing assets in non-cooperative jurisdictions. We have operational offices in several countries. As of October 2025, some countries are still not participating in the Common Reporting Standard, including the United States, which, however, uses FATCA to exchange data with other countries, even though it does not adhere to the multilateral CRS. Canada, some African states such as Guinea-Bissau, Burundi, or the Central African Republic, and small jurisdictions like Taiwan. Nevertheless, more and more countries are joining, such as Armenia, which joined in 2025. However, doing business with these countries does not guarantee tax anonymity. In fact, the authorities of European countries have alternative tools to detect hidden assets, including the exchange of information upon request as provided by bilateral double taxation agreements and international cooperation between tax police forces. Furthermore, transferring assets to non-CRS countries may constitute evidence of aggravated international tax evasion. Holding accounts or investments in jurisdictions that have not joined the CRS without declaring them results in administrative penalties ranging from 15% to 30% of the hidden amount if the country is on the blacklist. The tax authorities presume tax evasion purposes, shifting the burden of proof onto the taxpayer. In the most serious cases, the crime of unfaithful or fraudulent tax return may be charged with penalties of up to 8 years in prison. The authorities may order the preventive seizure of assets and wealth in countries such as Italy and abroad. Furthermore, the use of non-cooperative countries can worsen the charges in criminal proceedings, demonstrating the intentionality of concealment. The CRS 2.0, which is expected to take effect in 2026, will further reduce opportunities to hide assets, extending information exchange to cryptocurrencies as well. If you have assets in countries that do not adhere to the CRS or are considering this strategy, don't take the risk. Contact us for a confidential consultation and discover the legal solutions to regularize your tax situation and avoid penalties and criminal proceedings. ICAA is your ally in international tax management.